Companies Act, Section 354, Tribunal's power to ascertain the wishes of creditors and contributors in winding up. Section 354 of the Companies Act, 2013 empowers the National Company Law Tribunal, NCLT, to take into account the collective views of the company's creditors and contributors in matters related to the winding up of a company. This provision reinforces principles of participatory justice by ensuring that key stakeholders, those financially invested in the company, have a say in the conduct of the liquidation process, subject to the tribunal's discretion. Through this mechanism, the tribunal can seek clarity or consensus on specific matters, giving due weight to the monetary value of claims, in the case of creditors, and voting rights, in the case of contributors or shareholders. The section sets out the process by which such meetings may be conducted, who may chair them, and how their outcomes are to be presented to the tribunal. 1. Discretionary power of the tribunal to consider stakeholders' wishes. Under subsection 1 of Section 354, the tribunal is vested with the discretionary authority to consider the wishes of the company's creditors or contributors in connection with any matter arising during the winding up proceedings. This does not mean that the tribunal is bound by the wishes of these stakeholders. Rather, it may choose to consider their opinions if it believes such input would assist in making fair and equitable decisions. The tribunal may do so only when such wishes are substantiated by sufficient and credible evidence submitted during the course of proceedings. This ensures that the views considered are representative and properly verified, thereby protecting the integrity of the process. 2. Calling of meetings to ascertain stakeholders' views. If the tribunal determines that formal consultation with creditors or contributors is warranted, it may, under subsection 1b, direct meetings to be called for the specific purpose of ascertaining their wishes. The tribunal may specify the manner in which such meetings are to be called, i.e., convened, held, i.e., conducted procedurally, and conducted, i.e., including rules for discussion, voting, etc. This authority allows the tribunal to tailor the meeting procedures to suit the circumstances of the winding up process while ensuring compliance with principles of fairness and due process. 3. Appointment of chairman and reporting requirements. Under subsection 1c, when directing that meetings be held, the tribunal may also appoint a chairman to oversee and conduct the meeting in a lawful and orderly manner, ensure compliance with the directions and rules laid down by the tribunal, maintain neutrality and impartiality in overseeing discussions and voting. Report the outcome of the meeting back to the tribunal in a timely and accurate manner. This provision ensures that the process of obtaining stakeholder input is not only formalized but also independently managed and documented. 4. Consideration of the value of each creditor's claim. Subsection 2 of Section 354 emphasizes that when assessing the wishes of creditors, it is not merely the number of creditors that matters, but the value of their respective debts. In practice, creditors with larger financial exposure to the company's debts will have their opinions weighed more heavily. This reflects a proportional representation model, where voting or influence corresponds to the size of financial interest. It ensures that those most affected by the company's insolvency or asset realization process have a proportionately significant voice in decisions. This approach maintains fairness by giving due weight to stakeholders based on the extent of their risk or claim. 5. Consideration of voting rights of contributors. Subsection 3 addresses the process for evaluating the wishes of contributors, which typically refers to the company's members or shareholders who are liable to contribute to the company's assets in winding up. In this case, the tribunal shall consider the number of votes each contributory is entitled to cast. This is generally determined by shareholding patterns, as laid down in the company's articles of association or applicable law. The process ensures that those with larger ownership stakes or greater liability have a proportionately greater say in matters affecting the winding up. This provision ensures that representation is equitable and reflects the actual legal and financial interest of each contributory in the company. For more details, contact us.